Hello and welcome to part 2 of our presentation to landlords about what's happening with the rental reform coming on the 1st of May. This is our second presentation, and today we're going to be discussing what happens when your tenants have moved in, so managing a tenancy. Obviously part 1 was about the process before your tenant moves in, and the next one we'll be releasing in 2 weeks' time will be about ending a tenancy, but today we're going to focus on what happens once your tenant has moved in and how you're going to manage your tenancy under the new rules. So what we're going to look at today is what's going to happen on the 1st of May for tenants that are already in place, how to deal with pet requests, the changes towards rent increases and how you action those, and some more information on rental payments moving forward. So as you know, on the 1st of May, the Renters' Rights Bill becomes law, and on that date, all tenancies that are already in place will become an assured periodic tenancy, which we touched on in the first presentation. So ASTs will be no more. On the 1st of May, everybody moves to an APT. Even if they moved in on the 28th of April and signed a 12-month contract, on the 1st of May, it will become an APT. At some point this month in March, the government are going to publish an information sheet for tenants. It will be a small booklet detailing what the change will entail, what their rights will be moving forward. And it will be landlord's responsibility to issue that document to each tenant in place on the 1st of May. Now you've got until the 31st of May to do that. Normally your agent would do it. We will be doing it here at Infinite for landlords, but you do need to check with them, as it is the landlord's responsibility to serve this document to your tenant, not the agent. We'll be doing it here as standard for all our landlords, obviously, but just check if your other agents are doing the same. Now you can serve it to them via email, but you do need to have the tenant's permission. So you need to speak to them first, get it in writing. You can email this document to them, and then you can send this document via email, which will be a lot easier than putting it in the post. It's going to be sort of a 10 to 12 page booklet, my understanding is. Now, the only other exception on the 1st of May, which won't become an APT, we talked about in the last presentation, a small minority of tenancies that won't be an APT. So, for example, if the rent is below £1,000 a year in London, or if it's a lodger, so the landlord lives in the same property, then it won't apply. But also, any tenancy that's been served notice before the 30th of April won't become an APT. So that tenancy will stay as an assured short-hold tenancy until that notice is either expired or you have possession back. So just a quick reminder on that, if you are looking to serve a Section 21, it needs to be done before the 30th of April. After the 30th of April, you can no longer use a Section 21 to ask a tenant to leave. Now, regardless of what date before the 30th of April you served it, you've only got until the 31st of July to apply to the court for a possession order. So if you miss that date, the Section 21 will then become null and void. The tenancy will convert to an APT, and you will have to use the new Section 8 grounds, the new rules to ask your tenant to leave, which we'll talk about in the next presentation. Okay, so it's really important if you're thinking of selling your property in the very near future, or you want your tenant to leave, you need to make sure you hit those dates. So one of the key things with renters' rights is that tenants will now have more access to pets in their properties and in your properties. And there's been some sort of grey areas about this over the last few months with what will be allowed, what won't be allowed. But there's some guidance now that's been made very clear what you can and can't do. So you can only refuse a pet if there's an absolutely compelling reason to do so. And to be honest with you, there's very few reasons why you will be able to refuse a pet. The key ones are documented here. So if you've got a HMO and there's other tenants in the house to consider, then you can absolutely refuse. If the pet is unsuitable for the property, now this is where it does become a grey area, because what you think is unsuitable and what a tenant might think is unsuitable can quite often be two different things. If the pet's illegal to own, so if it's on a dangerous dog breed, for example, then you can absolutely refuse to allow the pet in the property. And if you're a leaseholder, so you own an apartment and in the lease it does not allow pets, or most leases certainly don't allow free roaming pets, dogs and cats, so you can absolutely refuse on that basis. Okay. What you can't do moving forward is you cannot have a blanket ban on pets. Doesn't matter what the property type is, each request for a pet must be considered on a case-by-case basis. So what will happen is, on the 1st of May, tenants don't automatically have the right to put a pet in the property, okay? They must still put the request to you in writing, and they must provide you with certain information about that pet in order for you to make a responsible decision. Once they've done that, you've then got 28 days to respond. Again, that needs to be in writing. But you can, within those 28 days, apply for more information. So if they haven't quite given you enough information about the pet, you can ask for more info, and then that will give you a further 7 days to respond to your tenant. If you don't respond within this time period, then the tenants will be able to take you to court and enforce rules that believe you're not meeting your obligations. Similarly, that's where that grey area of, is the pet suitable for the property? You might feel it's not, the tenant might feel it is. The tenant will have the option to go to the court, go to the council and say, under the renters' rights, you're not meeting your obligations, and then it'll be down to a judge effectively to decide whether that pet is suitable for the property. Our advice is to use a form similar to the one that we use. So we've created a form. There's a link on the presentation here to the form for you to go and have a look. So moving forward, any tenant who requests a pet, we will send this form to them, ask them to complete it and return it to us. And we'll then send this on to the landlord, so the landlord and ourselves can have a conversation and make a decision about the pet in question. So it asks for certain information about the pet and the owner, all reasonable. So things like, if it's a dog, how long will it be left at home on its own? Will it be microchipped, neutered, etc.? All things that are perfectly reasonable to ask, but it means you can then assess the pet request properly and make an informed decision. This will, again, coming back to that issue of, is the pet suitable or not, and potentially having to go to court. By doing something like this, you can demonstrate that as a landlord, you've been responsible, you've done everything that you can to try and accommodate the request, and you've made a decision based on the information provided by the tenant. Also, what the form does is it sets out the tenant's obligations. So it ensures that they know that, yes, you can have a pet. However, this pet is allowed in the property under certain conditions. We expect you to behave in a certain way. We expect the pet to behave in a certain way. And it can't cause a nuisance to other people. And it can't cause damage to the property above and beyond fair wear and tear. Rent increases. So again, there's some key changes here. Although many of our landlords won't really notice any difference. I'll explain why shortly. So after the 1st of May, rent increases can only be done via what's called a Section 13 notice. So this is a standard format letter that goes to a tenant to say, we want to increase the rent on this date by this amount. And it has various other bits of information in there which you need to serve as part of this Section 13. Now you can serve this via email. Under the new Renters' Rights Bill, they have really opened up the terms of which tenants and landlords can serve notice. So moving forward, everything used to have to be done in writing via post, etc. But now you can serve this via email. No other mechanism of rent increase will be acceptable after this date. So if you've got, for example, a tenancy agreement that's got a clause in it that says the rent can go up by 5% every year, that is null and void after the 1st of May. You will not be able to rely on that clause. That will be illegal. If you try and use that clause, the tenant again can take you to court because it's an illegal clause in a contract effectively. So the only way you can increase the rent is via this Section 13 notice. Now the other key difference here is you now need to give the tenant 2 months notice rather than 1. So at the moment, we only have to give the tenant 1 month's notice based on their rent payment date, but that's going to be extended to 2. And you can only serve this notice every 12 months. And I'll come on to some date timelines in a second to show you how that will work. So for example, if you have a tenant who moves in on the 1st of June, so after the renters' rights comes in, 1st of June 2026, then you must serve a notice before the 1st of April 27 for that new rent to start on the 1st of June 27. So 1st of June 27 is the earliest you can increase the rent because that's 12 months after they moved in. But you can serve the notice 2 months before that for it to start on the 12th month. Okay. If you miss that 1st of April date, then the 12 month starts from whatever the new date is. So for example, if you serve notice on the 20th of April rather than the 1st of April, you've missed a month effectively. So the rent increase won't then commence until the 1st of July 2027 rather than the 1st of June. But that will mean you then can't increase the rent again until the 1st of July the following year, 28, rather than go back to the 1st of June date. Okay, so it's 12 months from the anniversary of the tenancy or from when you last served a rent review. And that will apply to tenants that are in situ on the 1st of May. So if you serve a rent increase now, for example, the next time you can serve another rent increase is 12 months from today. The date doesn't reset again on the 1st of May. It's always based on a 12-month period. Now, the other key with rent increases is they can only be based moving forward on comparable evidence. Okay, so ideally, what you would do before you increase the rent is you would find comparables, Rightmove, On the Market, Zoopla, etc., and attach them to your rent increase notice to say, look, we're going to put the rent up to this figure. Here's the reasons why, and here's the comparable evidence to show that we're in market value, basically. If you try and use a notional figure such as inflation, cost of living, service charge has gone up, utility bills have gone up, they will no longer be acceptable. They've never really been acceptable anyway. However, now if you cannot provide comparable evidence that other properties are renting for the amount you're looking to charge, the tribunal will absolutely find in the tenant's favour. So anything where you say a notional rate of, right, I want it to go at 5%, for no reason other than think the cost of things are going up, then that would not be acceptable. The key difference here now is if the tenant doesn't agree with the rent increase, they can go to first tier tribunal, which has always been the case. If you look at section 13 notice now, it's got on there how tenants can dispute rent increases, but it doesn't tend to happen very often. But moving forward, there's a concern that it may become more common for two reasons. First of all, the tenants can dispute it with no cost to them at all moving forward. And most importantly, the tribunal will no longer backdate rent if it finds in the landlord's favour. So if you look to increase the rent by £100, tenant says, no, not happy with this, I'm going to go to first tier tribunal. And it takes 12 months for the tribunal to make a decision in your favour. Then effectively you've lost £1,200 in rent because they won't backdate it to the date the notice was served. They will only start the rent increase from the date the tribunal found in your favour. What they will do though, the date of the notice will still apply, so you can then still increase the rent again 12 months after you serve that notice. However, if the tenant decides to dispute that following notice, you're going to end up in a similar cycle. Okay, so there is a big concern that more tenants will start to dispute rent increases. Obviously, the information that the government is going to send out this month, or we're going to pass on to tenants on the 1st of May, is going to cover all these items with them and explain exactly what their rights are. So tenants are going to be more knowledgeable than ever about what they can and can't do. The key thing with all of this is to consult your tenant before you try and increase the rent. So the way we've always worked here at Infinite, landlord asks us to increase the rent. The first thing we'll do is have a conversation with the tenant. Landlord's looking to increase the rent. Here's the reasons why. You know, we've rented stuff in the area that's rented for that price, so we're comfortable it is market value. You know, are you going to be okay with that? And have that conversation before you even send the rent increase notice. Is really important, because if you just send a letter to say the rent's going to go up by £100, human nature is the tenant's back's going to go up and automatically they're on the defensive and they're going to look at ways they can try and dispute that rather than have a conversation with you after the point. If they're going to dispute it, you want to know about it up front. So if you're trying to increase it by 100 and they say, well, no, I'm not happy with that, can we agree on 50? You can get that done before you issue the rent increase notice, and it'll make it a much smoother process moving forward. So we covered rental payments a little bit last time, but one of the key things to point out here is that, as you know, after the 1st of May, you can only collect 1 month's rent at any time. You can collect less, so you can collect rent weekly, fortnightly, etc., but you can never collect more than 1 month's rent from a tenant after the 1st of May. Even if you've got a tenancy signed before the 1st of May, and it says the tenants pay quarterly, 6 monthly, 12 monthly, that cannot be enforced after that date, even if the tenant volunteers. And what I would suggest, if the tenant volunteers, do not take that money. You will get yourself in a lot of trouble. If the tenants will give you 12 months up front, whether they volunteered it or not, do not accept that money. Tell them they can only pay 1 month at a time. One of the key points, though, which we were never sure about until recently, is that on the 1st of May, if you have taken rent up front from a tenant, you don't need to refund any of that money on the 1st of May. You can still retain that rent. If they're paid up until the 1st of December 2026, that's fine, that's not a problem. It's just after the 1st of May, you can no longer take any more than 1 month's rent. So at some point in 2026 as well, we're expecting to see the Decent Home Standard come into play. So this comes back now to how you deal with maintenance and again, managing your property. The Decent Home Standard is already in play for social housing, but they're now looking to introduce this for private landlords. So effectively what it will do is it will confirm a minimum quality standard that a house needs to be in order to rent it to somebody, okay? It has 4 core criteria, but then there's lots of sub-hazards under those criteria. again, 99.9% of rental properties should meet this standard without a problem. But some of them, as you will see, will be very grey areas, and what someone decides is reasonable might not be what somebody else decides is reasonable. So you're going to see a lot more conflict under these rules between landlord and tenant moving forward. We've added some more information here about the Decent Home Standard and some of the things that were covered and what the criteria might be. The best thing I can suggest is a link on the bottom right of this screen. If you go and have a look at what the Decent Home Standard lays out, just so you've got some knowledge of it yourself, how you have to react as a landlord to things like damp and mould, things like noise insulation, if the bathroom's not working properly, kitchen's not working properly, you need to understand as a landlord what your responsibilities will be moving forward. There's key little things like homes must be equipped with window restrictors, which most houses might not be. So you might find you get maintenance requests come through for things like that, and you need to understand what you can and can't refuse. Because at the end of the day, what we will do as an agent, the tenant will make the request, we'll explain to them what the rules are, we'll then pass that request on to you, and it's down to you as a landlord to make a decision as to whether you feel that you're going to be meeting the standard or you're going to cause yourself problems if you don't do the works. So there's certain things that can make a property fail, and some of these might not be as obvious as you think. So damp and mould, obviously. Unsafe electrics or fire risk. This could be silly little things like missing smoke alarms, carbon monoxide alarms. Structural disrepair tends to be fairly obvious, but even little things like carpets coming up, trip hazard if door plates aren't fitted quite properly, things like those can be classed as category 1 hazard, and it will have some serious penalties. And councils have already got stronger powers to enforce, but once a Decent Home Standard comes in, those powers are going to increase even further. So you'll have civil penalties of up to £40,000 for serious breaches. Now that is per breach. So if the council goes into a property and finds there's no smoke alarms, there's damp, and there's no door plates, so everyone's tripping over the carpets, that's £120,000 potentially you can be fined. Okay, so it is really, really important that you understand what these rules are moving forward, and effectively you should treat your properties today like they come under a Decent Home Standard. That would be the best advice we can give you, so that when it does roll in, as a landlord, you're pretty bulletproof. Also, if you're not already aware, the new EPC rules are going to be coming into place on October 2030. Now, this has been around for some time. It was brought in under the Conservative government, and then they kept kicking the can down the road and changing the dates. It is highly unlikely now that this date will get pushed back any further. There is an election due before October 30. I'm pretty confident in saying. But regardless of what party is in power, this date will be baked in by that point, and it is very unlikely that it will change. So what will happen is, as it stands today, you can rent out your property if it has an EPC rating of E or above. There are certain exemptions to that. So grade 1 listed properties, for example, can be a grade F or G. But generally, every property needs to be a minimum rating of E. But on the 1st of October 2030, that's going to change to a C. So every property then must be an EPC C. Now, it doesn't have to be reassessed. You can use your existing certificate. So if you have a certificate done today, which will last until 2036, and it gives you a C rating, then that's fine. You're clear until 2036, regardless of what happens on the 1st of October. So as I say, any certificate issued now will remain valid until it expires, so normally for 10 years. What I would advise you is to start looking at your EPCs now, as in today. The reason being, over the next 3 years, the way that EPCs are graded is going to change quite significantly. So the EPC assessors are telling us that certain properties may be a C now, but may drop to a D. Other properties might be a D, could go up to a C. But the way that they score a property now for EPC is changing completely. So looking at things like how the building retains heat, rather than just its energy costing. So this could be things like how big are the windows, what insulation is there. So terraced houses, for example, should score relatively well if you've got a house either side, because you won't be losing heat to the sides. Whereas detached properties, obviously you lose heat out of 4 walls, so potentially you could actually get downgraded. What I would suggest is look at your EPCs now. If you've got a property that's a high D, start looking now at what you can do to get it to a C. It might be something really simple, like putting some TRVs on radiators, putting energy saving light bulbs in. Get the work done now and get a new EPC issued to give you 10 years of cover, basically, because then you'll go flying past the 1st of October 2030 date. Don't leave it to the last minute, because energy assessors will be unavailable. and tradesmen will be unavailable to do the work in 2029, 2030. I can guarantee. If you need big jobs doing like loft insulation, cavity insulation, you will struggle to get it done in the 2 years running up to that date. I can guarantee, because everybody will be just too busy. Now, there are other rules regarding the EPCs. So there is limits on what the government does expect you to spend on your house to get it to EPCC. So if you've got a property that is pretty poorly performing, they're not asking you to spend £50,000 on a property worth £60,000. That would be unrealistic and unfair. So there's a maximum spending cap of £10,000 per property. So if you can provide invoices that show, look, I've spent £10,000, I've had it reassessed, I still can't get it to a C, then the government can potentially give you an exemption certificate and allow you to continue renting that property. The current exemptions that are in place will still apply. So things like grade 1 listed properties will still be able to apply for an exemption certificate and will still be able to be rented. And that £10,000 cap is basically worked on 10% of the property value. So if your house is worth less than £100,000, then the £10,000 reduces. So it's 10% of the property value essentially. So for a property worth £90,000, you'd only be expected to spend £9,000 to bring it up to an EPCC. Okay, so what are we doing in order to help landlords with all the things we've just talked about? So with regards to rent increases, we've always worked on the Section 13 basis anyway. That's always how we've increased rent. So the process we use to increase rents won't need to change, other than giving the tenant an extra month notice. But what we will be doing moving forward now is when a new tenant moves in, we'll be setting the first inspection date 8 months after they move in, so that when we come to do the rent increase, we've got an up-to-date inspection report on file, which we can use to make sure we get the correct comparables and we're comparing like with like. So this is going to be really important moving forward, because it could be daft little things like there's a property down the road rented for £50 more, but that's got brand new carpet, it's been redecorated, new oven and hob. So your property is £50 less. We can't justify that £50 increase because it's a property in better condition. Or it might be the other way around. It could work in your favour. Your property is in far better condition. But it's going to be really important to have these inspection reports on file, so we can make sure we're using the correct comparables and we don't have too many disputes with tenants. Now, if you've got rent protection with us, then you'll be pleased to know that as of the 1st of May, that rent protection policy will include a Section 13 protection clause. So if one of your tenants does decide to dispute a rent increase, it goes to tribunal. Tribunal finds in your favour. As we've discussed, you've lost all that backdated rent, where your rent protection policy will now pay out. So they will pay out the difference from when you serve the notice up until the date the tribunal found in your favour. So effectively, all the rent that you've lost because the tenant disputed, the rent protection policy will pay out for you. That's only if the tribunal finds in your favour, obviously. If the tribunal finds in the tenant's favour and says, no, you were trying to put the rent up too high, the policy won't pay out. The new government booklet, we will be issuing to tenants for you, and we'll do that with an electronic receipt. So we'll make sure that every tenant signs it online, or we'll get a read receipt from their email to ensure they've received it, opened it, read it, and then you're covered as a landlord. That will be on file to make sure that if there's any checks done, we can confirm that yes, it was issued on the correct date. And we'll continue to use deposit replacement schemes such as Reposit, which give additional cover for our landlords. So if you're not already aware, we offer this on every property to tenants, which Reposit gives the tenant the option to pay a small premium. It's an insurance policy effectively, and it gives the landlord 8 weeks rent as deposit rather than the maximum 5 we can take as a cash deposit. If you don't know about Reposit, there's a link there for you to go away and have a look. We pretty much have a 100% claim record on Reposit. It's a really good product because our inventories and checkout processes is so good. It's very rare we have claims not back through Reposit. If you don't want us to offer Reposit on your property, please let us know so we can make sure we don't put it on the advert, because we tend to do it as standard. We can't make tenants take it out due to tenant fee ban. We can only give the tenant the option of using Reposit, and if they still want to pay a cash deposit, we have to allow them to do that, obviously. As always, if you have any questions about the things we've talked about today or in presentation number 1, please email us at info@infinitepropertyltd.com. Put RRB in the subject and one of my colleagues will come back to you straight away.